The Supreme Court erred in declining to sign the petitioner's order to show cause and in dismissing the proceeding in its entirety. Although the petitioners failed to set forth in their petition the exact subsection of 1921 upon which they relied, this defect was not fatal and should not have prevented the Supreme Court from signing the order to show cause, thereby permitting the petitioners to be heard on their application. See Howard versus Murray, 38 New York 2nd, 695, 699 to 700, 1976. Moreover, the Supreme Court erred in finding that the petitioners failed to allege or establish that they ever sought satisfaction of the mortgages from the respondents, or that the respondents failed or refused such satisfaction in response thereto. The verified petition does contain these allegations. However, the Supreme Court correctly determined that 1501 rather contemplates the commencement by way of summons and complaint of an action to cancel and discharge a mortgage on real property after the statute of limitations to foreclose it has expired. The courts are empowered and indeed directed to convert a civil judicial proceeding not brought in the proper form into one which would be in proper form, rather than to grant a dismissal, making whatever order is necessary for its prosecution. Matter of First National City Bank versus City of New York Financial Administration, 36 New York 2nd, 87, 94, 1975. However, the court must have jurisdiction over all of the parties before converting the special proceeding into an action. See CPLR 103C. Siegel, New York Practice, Section 547 at 905, 3rd edition. Here, since the order to show cause was never signed, there was no service of the petition on the respondents, and jurisdiction was not obtained over them. Thus, the Supreme Court properly dismissed that portion of the petition seeking relief pursuant to 1501 on the ground that it was improperly brought as a special proceeding rather than as an action. The petitioners may, if they be so advised, commence a separate action pursuant to 1501 so as to preserve their remedies. See matter of Key Bank of New York versus Del Norte Incorporated, 251, Appellate Division 2nd, 740, 1998. Matter of Golden, 227, Appellate Division 2nd, 401, 1996. Matter of Lester versus Bickford, 88, Administrative AD 2nd, 730, 1982. The Supreme Court improvidently exercised its discretion in sua sponte, imposing a sanction on the petitioners pursuant to 22 New York Supplement 130. A court may impose a sanction sua sponte, but the party to be sanctioned must be afforded a reasonable opportunity to be heard. See 22 and 130.1. Cangro versus Cangro, 272, Appellate Division 2nd, 286, 287, 2000. Morrison versus Morrison, 246, Appellate Division 2nd, 634, 1998. George versus Wyckoff Heights Hospital, 222, Appellate Division 2nd, 552, 1995. Finally, the petitioner's attorney did not file a notice of appeal on his own behalf, and therefore we do not review the propriety of the Supreme Court's determination imposing a sanction upon him. Accordingly, the matter is remitted to the Supreme Court, Westchester County, for further proceedings on the order to show cause and the petition insofar as they concern the claim to cancel and discharge the mortgages pursuant to 1921. Florio, J.P. In the matter of Lucia Plaza, in a hybrid proceeding pursuant to CPLR Article 78, in the nature of prohibition inter alia to preliminarily enjoin the respondents from acquiring a homeless shelter, and an action for a judgment declaring that a contract between the respondent Department of Homeless Services of the City of New York and the respondent Doe Fund Incorporated is illegal based on the respondent's failure to review it pursuant to the Uniform Land Use Review Procedure under New York City Charter, Section 197C, Proceeding Number 1. Okay.